Chapter 34. Special rules pertaining to process against the minister. Teaching Elder. 34-1. Process against the minister shall be entered before the presbytery which he is a member. However, if the presbytery refuses to act in doctrinal cases or cases of public scandal, and two other presbyteries request the General Assembly to assume original jurisdiction to first receive and initially hear and determine, the General Assembly shall do so. 34-2. As no minister ought, on account of his office, to be screened in his sin or slightly censured, so scandalous charges ought not to be received against him on slight grounds. 34-3. If anyone knows a minister to be guilty of a private offense, he should warn him in private. But if the offense be persisted in, or become public, he should bring the case to the attention of some other minister of the presbytery. 34-4. A. When a minister accused of an offense is found contumacious, 32-6, he shall be immediately suspended from the sacraments and his office for his contumacy. Record shall be made of the fact and of the charges under which he was arraigned, and the censure shall be made public. The censure shall in no case be removed until the offender has not only repented of his contumacy, but has also given satisfaction in relation to the charges against him. B. If after further endeavor by the court to bring the accused to a sense of his guilt, he persists in his contumacy, he shall be deposed and excommunicated from the church. 34-5. Heresy and schism may be of such a nature as to warrant deposition, but errors ought to be carefully considered, whether they strike at the vitals of religion and are industriously spread, or whether they arise from the weakness of the human understanding and are not likely to do much injury. 34-6. If the presbytery find on trial that the matter complained of amounts to no more than such acts of infirmity as may be amended, so that little or nothing remains to hinder the minister's usefulness, it shall take all prudent measures to remove the scandal. 34-7. When a minister pending a trial shall make confession if the matter be base and flagitious, such as drunkenness, uncleanness, or crimes of a greater nature, however penitent he may appear to the satisfaction of all, the court shall without delay impose definite suspension or depose him from the ministry. 34-8. A minister under indefinite suspension from his office or deposed for scandalous conduct shall not be restored, even on the deepest sorrow of his sin, until he shall exhibit a considerable time such an eminently exemplary, humble, and edifying life and testimony as shall heal the wound made by his scandal. The deposed minister shall in no case be restored until he shall appear that the general sentiment of the church is strongly in his favor and demands his restoration, and then only by the court inflicting the censure or with that court's consent. The removal of deposition requires a 3/4 vote of the court inflicting the censure, or a 3/4 vote of the court to which the majority of the original court delegates that authority. 34-9. When a minister is deposed, his pastoral relation shall be dissolved, but when he is suspended from office, it shall be left to the discretion of the presbytery whether the censure shall include the dissolution of the pastoral relation. 34-10. Whenever a minister of the gospel shall habitually fail to be engaged in the regular discharge of his official functions, it shall be the duty of the presbytery at a stated meeting to inquire into the cause of such dereliction and, if necessary, to institute judicial proceedings against him for breach of his covenant engagement. If it shall appear that his neglect proceeds from only his lack of acceptance to the church, presbytery may, upon the same principle upon which it withdraws license from a licentiate, for lack of evidence of the divine call, divest him of his office without censure, even against his will, a majority 2/3 being necessary for this purpose. In such a case, the clerk shall, under the order of the presbytery, forthwith deliver to the minister concerned a written note that at the next stated meeting the question of his being so dealt with is to be considered. This notice shall distinctly state the grounds of his proceeding. For this proceeding, the party thus notified shall be heard in his own defense, and if the decision pass against him, he may appeal as if he had been tried after the usual forms. The principle may apply, with any necessary changes, to ruling elders and deacons. Chapter 35. Evidence. 35-1. All persons of proper age and intelligence are competent witnesses except such as do not believe in the existence of God or a future state of rewards and punishments. The accused party may be allowed, but shall not be compelled to testify. But the accuser shall be required to testify on the demand of the accused. Either party has the right to challenge a witness whom he believes to be incompetent, and the court shall examine and decide upon his competency. It belongs to the court to judge the degree of credibility to be attached to all evidence. 35-2. A husband or wife shall not be compelled to bear testimony against one another in any court. 35-3. The testimony of more than one witness shall be necessary in order to establish any charge, yet if, in addition to the testimony of one witness, corroborative evidence be produced, the offense may be considered to be proved. 35-4. No witness afterwards to be examined unless a member of the court shall be present during the examination of another witness on the same case if either party object. 35-5. Witnesses shall be examined first by the party introducing them, then cross-examined by the opposite party, after which member of the court or either party may put additional interrogatories. No question shall be put or answered except by permission of the moderator, subject to appeal to the court. The court shall not permit questions frivolous or irrelevant to the charge at issue. 35-6. The oath or affirmation to a witness shall be administered by the moderator in the following or like terms. Do you solemnly promise in the presence of God that you will declare the truth, the whole truth, and nothing but the truth, according to the best of your knowledge in the matter in which you are called to witness, as you shall answer it to the great judge of the living and the dead? If, however, at any time a witness should present himself before a court who, for conscientious reasons, prefers to swear or affirm in any other matter, he should be allowed to do so. 35-7. All testimony shall be recorded, transcription, audio tape, videotape, or some other electronic means, and witnesses informed of such prior to testifying. Such recording becomes part of the record of the case. However, in order to be referenced in written or oral briefs, such recording must be transcribed and the transcription authenticated by the trial court. The Court of Final Appeal may assess the cost of transcription equitably among the parties. 35-8. The records of a court or any part of them, whether original or transcribed, if regularly authenticated by the moderator and clerk or by either of them, shall be deemed good and sufficient evidence in every other court. 35-9. In like manner, testimony taken by one court and regularly certified shall be received by every other court as no less valid than if it had been taken by itself. 35-10. When it is not convenient for a court to have the whole or perhaps any part of the testimony in any particular case taken in its presence, a commission shall be appointed or a coordinate court requested to take the testimony in question, which shall be considered as if taken in the presence of the court. Due notice of the commission or coordinate court and of the time and place of its meeting shall be given to the opposite party, that he may have an opportunity of attending. If the accused shall desire on his part to take the testimony at a distance for his own exculpation, he shall give notice to the court of the time and place at which it shall be taken, in order that the commission or coordinate court, as in the former case, may be appointed for the purpose. Testimony may be taken on written interrogatories by filing the same with the clerk of the court having jurisdiction of the case, and giving 2 weeks' notice thereof to the adverse party, during which time he may file cross-interrogatories if he desire it. Testimony shall be taken by the commission or coordinate court in answer to the direct and cross-interrogatories, if such are filed, and no notice need be given of the time and place of taking the testimony. 35-11. A member of the court shall not be disqualified from sitting as a judge by having given testimony in the case, unless a party makes an objection and the court subsequently determines that such member should be disqualified. The elder against whom the objection has been made shall retain the right to vote in the determination of qualification. A member of the court who is the prosecutor in the case BCO 31-2 is disqualified from sitting as a judge. 35-12. An officer or private member of the church refusing to testify may be censured for contumacy. 35-13. If after trial before any court new testimony be discovered which the accused believes important, it shall be his right to ask a new trial, and it shall be within the power of the court to grant his request. 35-14. If, in the prosecution of an appeal, new evidence be offered which, in the judgment of the appellate court has an important bearing on the case, it shall be competent for the court to refer the case to the lower court for a new trial, or with the consent of parties to admit the evidence and proceed with the case.